Attorney Jonathan D. Moeller. Today we'll be talking about the Massachusetts law involving eviction storage, which is covered in Massachusetts General Laws, Chapter 239, Sections 3 and 4. Now, the Massachusetts Eviction Storage Law provides protections to Massachusetts residents who are facing an eviction or who have already been evicted from their respective apartments. If you're unable to find a new place to live after being evicted from your premises, your landlord must put your belongings into an eviction storage facility licensed under the laws of the Commonwealth of Massachusetts. Now, there are a number of statutorily defined requirements that a landlord must follow in storing and removing your property. Now, to legally evict you and remove you and your belongings from your residence, your landlord must get a court order. This court order is called an execution. So following an eviction trial, if the landlord gives what the court calls possession of your apartment, the court will give the landlord this court order, which again is called an execution. The landlord then gives this court order to a constable, who's the only person who can legally move you out. The landlord does not have a right to physically remove you or your property. The constable who comes to your residence must give you prior written notice at least 48 hours before he or she comes to physically remove you or your property. This 48-hour period does not include weekends or holidays. Now, under the Massachusetts storage law, the constable's notice must have certain information in it so that if you cannot move out within the 48 hours, your property will be protected. The 48-hour notice must contain the following: the date and time of the constable's arrival, must contain the constable's contact information, must contain the court information where your eviction action took place, must also contain a statement that the storage company is licensed pursuant to the laws of the Commonwealth, must also contain the storage company's contact information as well as their storage fee information. Now, very important, the 48-hour notice also must contain a statement that the storage company may sell your property if you do not claim it after 6 months, and that the funds from the sale can and likely will be used to pay any unpaid storage fees which are owed by you. Finally, this 48-hour notice must contain a statement that you must notify the storage company in writing of any change in your mailing address. Now, additionally, the constable is required under the law to make a list of all belongings he or she is removing from your property. They must give you a copy of this list. They must sign this list and file it in the court where your eviction action took place. Now, the storage law requires the constable who's evicting you to move your belongings to a licensed public warehouse. Now, what that means is the public warehouse has been licensed by the Department of Public Safety to store items. Within 7 days of your properties having been put in storage, the storage company is required to mail or hand deliver you a written receipt that lists its storage rates. Additionally, the receipt must also include the following information. First and foremost, it must contain a statement that after 6 months, the storage company may sell any of your unclaimed property at an auction and keep the money from the sale for storage fees that you have not paid as of the auction date. Next, must contain a list of storage rates. Also, the receipt must contain a clear and obvious statement that you should notify the storage company in writing if there's a change in your mailing address. The receipt must also contain a statement on how you get your property back and your right to access your belongings once for free. Now, storage companies should keep a copy of this receipt on file at the warehouse in addition to giving you one. Storage charges. The rates charged by the storage company must be filed and not rejected by the Department of Public Safety. Additionally, the storage company can only charge you for the actual storage of your property, so it cannot charge hidden or additional fees such as docking fees, administrative fees, or warehouse labor fees. Now, the million-dollar question under the statute: who pays for the property to be moved and stored? Well, I'm sure as you gathered by now, you as a tenant are responsible to the storage facility for all storage fees. However, the landlord is responsible for the cost of moving your property or belongings to the storage facility. The landlord can seek reimbursement. This usually manifests itself through the court process, so the landlord can file a civil action against you for the cost of the moving fees in district or small claims court. Now, access to your belongings. Under the storage law, you have a right to get into your stored property once free of charge to inspect the property or to remove items that have a personal or sentimental value. Such items include pretty much anything: photographs, passports, anything that has personal or sentimental value to you. Always remember, you can always gain access or get your belongings back by keeping current on your storage fees. Now, in the case that your property is damaged while it's being moved or stored at the storage facility, well, all parties have a duty of reasonable care under the law. What this means is that the storage company, the constable alike, must treat your stored property with the watchfulness and care that any reasonable person would use in the same circumstances. So what I usually tell people is that when you gain access to your belongings at the storage facility, if you notice anything's damaged, make a list of it, bring it to the storage facility's attention. This is a good tool for negotiating your storage rates down. And if they don't come to the table, you're certainly always welcome to file a civil suit in the district, housing, or small claims court. Now, what should you do if a constable, landlord, or storage facility violates any provision of the Massachusetts eviction storage law? Well, you can always call the Attorney General's office. They have a consumer complaint hotline. It's 617-727-8400. You can also notify the Department of Public Safety. And finally, you yourself can file suit in the housing court, the district court, or the small claims court. So there you have it, a brief overview of the Massachusetts eviction storage law. Now, there are many formalities and requirements that landlords, constables, and storage facilities are required to follow. It's important to know that you have rights under the law, even after a court has ruled against you in an eviction. The Massachusetts storage law was enacted because landlords are violating the rights of evicted tenants and throwing away or unlawfully withholding their belongings. If you've been a victim of an unfair, deceptive act by your landlord, or your landlord's violated the Massachusetts eviction storage law in any way, you can always contact me at my email, johnmoeller@live.com, or call me directly at 508-579-8333. Remember, initial consultations are always free and confidential. Thank you for watching.